Thank you very much for all these inspiring inputs so far, and thank you, Marike, for this opportunity to present a piece of research conducted in collaboration with my colleague, Werner Zell Schäfke. In consideration of the ongoing digitalization, we outlined 3 potential transformations in the legal profession. So in the next 10 minutes, I will introduce these 3 transformations or pathways, if you will. And then my colleague, Werner Zell Schäfke, will say more about the nature and background of these pathways. So just before I introduce them, a few words about the basis of these 3 pathways. The pathways are developed on the basis of sociological models of the legal profession and legal market, as well as sociological descriptions of the history of legal professions over the past century. And to concretize these hypotheses, we focus on 3 similar countries between which there is some level of comparability, and that is Denmark, Germany, and the Netherlands. The pathways are meant to be non-mutually exclusive. In other words, or to explain, they can be at play simultaneously, and they can be more or less influential. Time will show, I should say. These pathways are, of course, very relevant in order to prepare law students for the digitalized future. So let's move into the introduction to these pathways. Pathway 1 is about creating legal quality and trust. There's no doubt, and we've already been around it, that the legal services are becoming more and more automated, and to succeed, the body of law has to be incorporated in a way that compromise as less as possible with the legal quality. So creating legal trust in the automated legal services is a complex task that calls for deep understanding of both law and technology, and how this in combination changes the process and decision making. So in other words, future lawyers have to do regulation and coding of legal technology in order to create trust in digital legal output. Examples could be credentialization of legal technology, as well as the creators and operators. So in regards to education, this pathway calls for professionalization of legal IT competences. So to use an example most people would know, it could be a kind of applied mode of science and technology studies, as most of you would probably know. That I think we've been to a large extent around this, but then pathway 2 is about the irreducible human element. While more and more routine-based legal services are automated, competition will increase regarding the non-automatable elements of legal service. An example of the irreducible is the client's need of recognition. It is thus impossible for a lawyer to empathize with his client's situation when there's no human contact. And one area of the legal market where lawyer-client interaction especially stands out as a core element of legal labor is ADR. That means alternative dispute resolution. as mediation, negotiation, conciliation, arbitration, conflict prevention, and so on. The decreasing demand for traditional legal services could very well expand the integration of ADR by offering new services and improve the existing legal services with more mediation, negotiation, and so forth. Moreover, as new technology makes it possible to use ADR in conflicts where the parties live far apart, the so-called online dispute resolution, the field of ADR is expected to be enlarged, and the potential of ADR is far from exhausted. So there is room for legal professionals to expand the market of ADR. The primary competences that would be required for lawyers according to this pathway is understanding of conflicts, mediation, rhetoric, communicative competences broadly within a vast variety of contexts. Pathway 3 is about revitalization of legal professionals as guardians of the rule of law. Digitalization also means loss of transparency, as the first one here at this conference mentioned. Loss of transparency. A decision-making process of machine learning algorithms is not transparent. It's not explained. So this lack of transparency may lead to reduced public trust in the rule of law, as the reasons behind the legal decisions are not possible to follow by the affected persons. They are also addressed with a legal they are solely addressed with a legal decision. So if citizens are to trust these automated legal decisions, it will be necessary to legitimize the process and its results to the affected citizens. And this call for a clarification of how decisions are following the regulation. And this may revitalize the post-war ideal of lawyers as guardians of the rule of law. We probably all know about the growing number of incidents and scandals in Danish and German public administration, where officials and politicians have been very creative in their interpretation of law. And they have, as you know, even been acting illegally. Decisions has been based on politics rather than the law, and that is for good reasons seen as a threat to democracy. So on this note, it has already been pointed out that I could say, on this note, it has already been pointed out that there is this need of a revitalization of administrative legal staff as guardians of the rule of law. So in this slide, the digitalization only adds to a call that is already at stake. So therefore, in terms of education of law students, it is important that the students doesn't only adapt to exclusive doctrinal legal knowledge, but also conduct competences to actually apply this knowledge in a daily practice that includes ethical dilemmas. So they have to learn codes of ethical conduct and they need hands-on training on how to translate ethics into practice. So to sum up on the question, what will be the core tasks of tomorrow's legal practitioners for which law schools have to prepare their students? Well, according to these three mentioned pathways or trends, the students will need to be able to build and increase public trust in the legal system. They will need a high degree of understanding of technology and how it influences legal process and decision making. They need to know how to practice on ethical terms, and they have to conduct more knowledge about dialogue-based dispute resolution and communicative competences more broadly, no less. Well, now I'll give the word to Werner, Zell, Schäfke, who will deepen and elaborate on the background of the three trends that I introduced. Thank you for the attention.
Also, thank you very much for the warm introduction, Mareike, and it's nice to work again with you, Ida. So as you may know, our talk is based on a research paper that's already published, which we wrote 3 to 4 years ago, when the talk about digitalization was more on the day-to-day agenda, but more as a thing still to come. And not something that we already experienced. So all what we know with a pandemic, with the rule of law at the EU level, at an international level, being direly threatened, all that wasn't as terrible as it is now. So this is a bit of a talk from the past, and I'm looking very much forward to seeing some more in-depth approaches about the individual topics that we are only looking at from a very abstract and theory-led level. So what we did is picking up individual theories that seemed well suited to look at what might happen and hypothesizing and looking at, is there something imminent back in 2018 that might highlight where these theories might actually be true. So let's see what has happened to our ideas later in this conference. So as Ida pointed out, automatization may lead to the emancipation of clients from the legal profession. A process called deprofessionalization, where the previously monopolized services delivered by the legal profession might be delivered through, well, machines, so to speak, through software. Maybe with certain interaction by human beings, as we already have heard about, that you may need some professional oversight. How do these machines work? How are these decisions made? And maybe credentialize people who code and develop such software. Which means, as a result, that there may be fewer legal jobs that in turn demand higher order competencies. And the research question arising from that is, how could we curb deprofessionalization? How can we care for legal jobs still existing? Back in 2018, there was more of a scare that maybe the legal profession is totally replaceable by machines, or maybe it isn't. So the talk has changed a bit since then. And how can we transform legal education to educate students for an automated legal profession? To put it briefly, and to start out with the arguments or the observations by Talcott Parson, legal services are more or less monopolized by the legal profession through the following arguments: that they require the mastering of a traditional cultural technique, which may be called the legal method or thinking like a lawyer. It requires expert knowledge that you only can gain through monopoly educations, and it requires a lengthy, difficult training. How much authority of science-based knowledge also applies to the legal profession and legal research, as you know, is debatable. So there's in various countries debate about, well, is legal research more scholarship or is it science? A distinction which is not made terminologically in German, but you also have the discussions there. Maybe they are not as acute at the moment as they have been a couple of years ago. So this leads to a professional monopoly. and this ensures customer dependence to the profession. Through automatization, it may come to a process called rationalization in the literature. That means a common belief that all professional tasks are automatable, which would mean that the arguments that mystify how lawyers work lose their power, which leads to a loss of the monopoly. And you could only curb it by highlighting that there is an irreducible human element necessary in legal work, and that this idea is also taken over by the clients or by citizens that are subjected to administration, that they say, well, we want a human element in it. So there's some non-automatable legal commodities that the profession retains a monopoly over. So what competencies do they need? What would be the characteristics of non-automatable legal labor? And here there's a very nice citation I want to give you during this talk by Richard Abel, a classical legal sociologist, who says, professional services contain an irreducible element of uncertainty or discretion, a delicate balance between indetermination and technicality, art and science. And this is also what I hinted at in a slightly different way when I earlier mentioned Ron Dworkin, that you always have to, as a lawyer, think about the purpose of a certain piece of regulation. What are the goals? What is the telos? This is sort of looking at it in another way. There's always a human element, an uncertain element. Not everything can be coded in a way. Not everything is purely formal. And that is the aspect we want to focus here, not so much in how can we make this human element digital, but more like, well, this is the human element, let's keep it. What does it mean if we can't digitalize this? And as Ida pointed out, there's 3 fields, which I will just jump over now because time is running out and you already heard it, and cut to the chase. One classical example, the solo taxonomy. If you had any contact with university level education or scholarship of teaching and learning, you may have heard about this taxonomy or similar ones. Means that we are going to have to focus on these higher order competencies, not so much at like applying what would be an applicable legal norm, understanding how certain legal norms interact with each other, but more like the communication with the client and how to create solutions. This one is fairly old school. So we did an empirical study of lawyers, and this was like one of the most important tasks that identified. This not so much. So this might be the stuff of the future. This, which also requires that students have an insight in, for example, how does legal tech work, or more importantly, how does society work? How do we create social cohesion? How does the rule of law benefit society, and how can we work towards managing actual social conflict? So it's very much about all the things that otherwise are hidden in the curriculum in sort of general subjects, such as legal philosophy or theory of the state and these kind of things. So it has to become a bit more sociological in a way, but in an applied way. And now to finish up, only a few seconds left. The proposed solution would be that the learning environment of students must approximate the complexity of relevant real-world tasks. And this goes a bit beyond just case-based learning. And they have to draw upon other relevant academic disciplines to qualify their higher order competencies. They do not only have to learn how to argue nicely, but they also have to know how does rhetorics work, for example. Just to give like a very easy example, but if Ida mentioned science and technology studies, you can go much more hard sciences and wet sciences about it than just like classical legal subjects borrowed from other academic disciplines. Sorry, that's the timer that's run out. That students are also, or graduates are also able to deliver research-based solutions. There are obstacles from an institutional level, maybe much more so in Denmark than in Germany, can speak of that situation, but there is the perception that law schools are gatekeepers for reproducing a country's elite. And therefore, there's a value in upholding traditional curricula that are more or less perceived as students' will to endure long and strenuous education, not so much as teaching them something. So there have to be established new ways of gaining symbolic capital as a lawyer That may be, as you pointed out, fulfilling the client desire for social cohesion. So briefly, you have a cycle of, well, you have a reformed curriculum, you have reformed graduates, their good work in society improved the image of the legal profession. Therefore, professional stakeholders endorse curricular reform. The big problem is, well, you won't have reformed curricula until professional stakeholders endorse a reformation of curriculum. So the solution to this conundrum is, if you're working in scholarship of legal teaching, learning, and curricular design for legal education, so you have to work politically. This only helps if you get, for example, your dean or your pro-dean of education to work with you to get stakeholders, external stakeholders on your side. Otherwise, curricular reform won't happen. And lastly, if there's a single text on university level education you're ever going to read in the future, make it this one. It's fairly old, but it's the one I cited regarding that university should emulate real world problems. It's the best text. Everything else is dispensable. Read this one. It's direly overlooked in my opinion. And this may actually be the key to more or less successful implementation from a didactical point of view. So thank you very much, and looking forward to your questions.